Now coming to nullity of marriage and divorce. This is discussed in chapter 4 of the Hindu Marriage Act 1955. That is chapter 4 deals with the nullity and divorce. Nullity of marriage and divorce. Nullity and marriage and divorce. So section 11, void marriages. Void marriages. That the term void marriage itself, we are clear that it is clear that the marriage is a invalid and it is not having any sanctity under the law. How? What makes the marriage invalid or void? That we will discuss, we will see now. Any marriage solemnized after the commencement of this act shall be null and void and may, on a petition presented by the either party thereto against the other party, be so declared by the decree of nullity if it contravenes any one of the conditions specified in the clause 1, clause 1, clause 4, clause 5 of section 5. As we all discussed in the section 5, the conditions of a Hindu valid marriage. So what is section 1 deals with? Section 1 deals with the either of the spouse leaving, either of the spouse leaving, sorry, I'll go through this. So both the parties to the marriage shall be single. So either of the spouse has a spouse leaving at the time of marriage. So no spouse to the marriage shall be having a spouse at the time of marriage. So as we discussed that, so A and B are getting married. So both shall be single or both shall be single. Like in many ways, like divorced, both are divorced. So there should not be any kind of previous relationship. So if A and B marries, suppose if A is already married to someone, so prior to this marriage, if he marries B, then what will happen means A marriage with the B is invalid. Why? Because there is a marriage already existing. And that marriage is not dissolved by a decree of divorce. So in that case, the marriage between A and B is void marriage. Why? Because it is contravening the provision that is essential condition of section 5 subsection 1. So that is void marriage. That becomes void marriage. Now coming to 4 and 5, subsections 4 and subclass 4 and 5 of section 5, that deals with the Kapinda marriages and degrees of prohibited relationships. So in our case, we have already discussed about the Andhra area relationships like that. So if a marriage is recognized, if the custom and usage is recognized, if the degree of prohibited relationship, custom and usage has been recognized for a long time, that has to be proved by the parties who are doing the same. So that marriage, that means that the marriage that was happened in Andhra areas, which was accepted by the public and which has been practicing since long back, that does not falls under the void marriages, as we discussed in our discussion earlier. So this act makes that, so the marriages which within the degrees of prohibited relationship, within the Sapindas relationship, are void marriages. Adding to that, and the persons who have already married and marrying to some other person is also invalid in the eye of law in view of section 11, that it will becomes in void marriage. So coming to the voidable marriage. So voidable means it may become invalid or become a valid. That will be at the option of the parties. So voidable marriages. So if we read section 2, all these voidable marriages, any marriage solemnized, whether before and after, so this has to be read clearly. Okay. So if you read section 11, that section will discuss us after the enactment of the act, after the commencement of the act, whatever the marriages that were happened, that was solemnized after the commencement of the Hindu Marriage Act, only it has application. For all the marriages which was performed prior to the 1955, that is enactment date, for those acts, For those marriages, section 11 has no application. We have to remember this thing. Why? Because section 11 has only prospective effect but has no retrospective effect. Now coming to section 12, viable marriages. It has prospective and retrospective effect. Any marriage solemnized whether before or after the commencement of this act shall be voidable and may be annulled by a decree of nullity on any of the following grounds, namely, the marriage has not been consummated owing to the impotency of the respondent. Second one is that the marriage is in contravention of the conditions specified in the class 2 of section 5. So here, if the respondent is impotent and who is not fit for consummation, that marriage. Why? Because the very purpose of the marriage is to create the lineage and offsprings of the persons. In other sense, we can say it as a for one person, for one man, one woman. Then for all the things that has to be between the two persons only, not from the third person. And so impotency, the potency is one of the essential thing to create the offsprings. That means to create the next generation of them and to continue their lineage. So that is also one of the purpose of the marriage as per the Hindu mythology. Now we can see here that the impotency of the respondent is one of the ground for making the marriage voidable. Why means voidable? As we discussed in the beginning of the section itself, voidable means we can make it void or we can accept it. So in this case, for some couples, having children is an option. For some persons, it becomes mandate. I mean, they wants to have children. They wants to procure. I mean, they want to create their offsprings. So here, if the person, if any of the person if any of the spouse feels that is okay, that is not an issue for the marriage, for leaving two couples, for having a good life between two persons. So that is a viable marriage. So viable marriage, they can have it, they can accept it, and they can continue in their relationship. So to the persons who wants to continue their lineage, like that we can see this kind of marriages in our olden days, like a male person who definitely wants a potent wife. That means who can able to produce children. So in those cases, we have seen a lot of persons who has a lot of men who has practiced a lot of cruelty against the women in olden days for not giving birth to child. So in that cases, so if a woman is impotent, they can take a divorce. They can get the marriage voidable. I mean, they can get the marriage void and by a decree of void from the court. So this, but presently this it has been increased in present cases also. The thing is, there is a change in this practice. Like the women are filing cases against the men because of the impotency. So now coming to subsection 1, clause B. We have discussed clause A. Now we are seeing clause B. So the marriage is in contravention of the conditions specified in the clause 2 of section 5. What is clause 2 of section 5 deals with means we can literally discuss about the consent from a unsoundness person. So if these facts are suppressed, if these facts are suppressed, and if the
Anil Kumar garu. Okay.
No, sir. Okay, sir. So if the marriage was performed in contravention to this consent clause in section 5, then we can make the marriage as voidable. Why? Because that is the option of the parties to make it void, or they can accept to continue in the relationship. For some persons, it is okay. I mean, in case of a unsoundness, in case of a unsoundness person, I mean, insanity. If a person is suffering with insanity, who is getting attacked with some kind of recurrent attacks of insanity during some specific periods, for that person's that is understanding between the couple. They if they want to continue, let it be okay. That will be for a few months. That is okay, fine. So that is between the couples, that as per their understanding, so they can make it as a void or voidable. So the consent that was obtained by during that course can be make it void, and we can make a we can put an end to the relationship by invoking this section, this subsection 1b of section 12. Here we can see is class C, uh, class C of subsection 1. So that the consent of the petitioner, or where the consent of the guardian in marriage of the petitioner was required under section 5, as it stood immediately before the commencement of the Child Marriage Resistant Act, the consent of such guardian was obtained by force or fraud or nature of ceremony. So here, as we discussed about section 6, so if the consent of a if a consent of a person to the marriage, or the, I mean, consent of persons, in a sense, we have to read in the by coupling, by clubbing with this guardian. So for a bride who is under the age of 18 years, as we discussed, the consent should be given by the parents, that is guardian, as discussed. So guardian, when a consent of the guardian is obtained by practicing the deception, by practicing fraud, by something else. So if the consent is obtained by fraud or something, coercion, or by practicing some kind of influence, then such consent is a invalid consent, and we can go to the court and ask the court to grant a decree for making the marriage void, on the ground that the consent is obtained by force or coercion or something that was discussed in this thing. That the respondent, and now coming to class D, that the respondent was at the time of marriage pregnant by some person other than the petitioner. So if it is specifically mentioned pregnant by some person other than the petitioner. So here this provision is specifically for a man who came to know that his wife was already pregnant, not through by him. So in that case, he can file a petition to make the marriage void. If he wants to put a break, if he want to break the marriage tie, he can file a petition to make the marriage void. No, otherwise, if he is okay, if he is if he knows it, and if he continues to continue with that lady after getting knowledge about the same, then it will be, we can take it as implied from circumstance that he has accepted the marriage, and he can make it voidable. That means he can accept the marriage without proceeding to make the marriage void. So here there's a limitation in this section. Means whenever he has discovered the fact that she is a pregnant, not by him, then he has to make the petition within 1 year from the date of knowledge of such recognition, which from knowledge of such discovery that the woman is pregnant. So within 1 year, he has to file a petition before the court. He has to file a petition before the court to asking for the decree of nullity, or nullity of the marriage, decree of nullity of the marriage. Now coming to subsection 2 of section 2. Notwithstanding anything contained in subsection 1, no petition for annulling of a marriage on the ground specified in class C of subsection 1 shall be entertained if the petition is presented more than 1 year after the force had ceased to operate, or as the case may be, the fraud has been discovered, or the petitioner has, with his or her full consent, lived with the other party to the marriage as husband or wife after the force has ceased to operate, or as the case may be, fraud has been discovered. So in this case, as we discussed in this section C, subsection C of section 1, if the consent is obtained by practicing fraud or some coercion or some force or something else, if the party wants to put an end to the marriage, he or she has to make an application within 1 year from the date of such discovery that the fraud has been practiced, or the fraud has been ceased to operate. So if any person continues having the knowledge for years together, like after knowing fully well that after knowing that the consent was obtained by fraud, if a person, he or she, may lives for years together, like 3 or 4 years or 5 or 6 years, and they procreate children. They procreate children knowing fully well that the consent was obtained by fraud. In that case, he or she cannot come and ask the court that my consent was obtained long back. So I know that I know it very recently. Uh, I know it so and so date. So please entertain my petition. That is not entertained. Why? Because there is a specific limitation of 1 year from the date when you have discovered that your consent is obtained by misrepresentation, by false statements or something else. You have to ask for this relief. If you want to exercise this relief, definitely you have to make application within 1 year from such discovery. Now coming to subsection 2, class B, on the ground specified in class D of subsection 1 shall be entertained unless the court is satisfied that the petitioner was at the time of marriage ignorant of the facts alleged. So if he is ignorant of the fact that she is pregnant, so then the petition is entertained. Entertained. That too has to give the statements to the satisfaction of the court. Next, the proceedings have been instituted in the case of a marriage solemnized before the commencement of this act, within 1 year of such commencement, and in case of marriage solemnized after such commencement, within 1 year from the date of marriage. So, if the section, if this kind of, as discussed in subsection 1D, if the pregnancy is discovered prior to 1 year, so this application is given, that is retrospectively 1 year prior to the marriage, prior to the enactment, and discovery is made within 1 year prior to the enactment, and within 1 year prior to the enactment. So that was given in this case. Proceedings have been instituted. Okay, next, that the marital intercourse with the consent of the petitioner has not taken place since the discovery by the petitioner that the existence of the said ground. So after discovering the fact that she is pregnant, not by him, not through him, so there is no cohabitation between them, there is no marital intercourse between them for more than many periods. So that will be a ground for them to ask, that will be a ground for them to file application under this act, under this section. So wait a minute, sir, please. Now coming to the section 13, grounds of divorce. Divorce. So here there are certain grounds wherein you can ask for the divorce, wherein the aggrieved party can ask for the divorce. Any marriage, whether solemnized whether before or after. See the wordings of this section. This section is also have application retrospectively and also prospectively. Whether before or after the commencement of this act may, on a petition presented either by the husband or the wife, be dissolved by a decree of divorce on the ground that the other party, now the grounds are mentioned. That So first thing, first subclass, I mean subsection 1, clause 1, wherein it is mentioned that has after the marriage, after the solemnization of marriage, had voluntarily sexual intercourse with any other person other than his or her spouse. So if a person who is having a extramarital life, that is who is having who had sexual intercourse other than with the spouse, so that will be a ground. So whenever a person alleging this ground, the burden of proof heavily lies upon the person who is alleging that my spouse, that is the other party, is in extramarital relationship with someone else, and who had also had an extramarital intercourse with other person. So in this case, they have to prove it strictly with all the proofs. So that is one of the ground. So having extramarital relationship, extramarital sexual relationship with other person is a ground, other than the spouse, is a ground for the divorce. Now coming to subsection clause 1A, 1A. He has after the solemnization of the marriage treated the petition with the cruelty. Treated with the petition with the cruelty. Here it was mentioned that cruelty. So the cruelty may be by words, that is mental cruelty and physical cruelty. For physical cruelty, there will be certain some sort of evidences like uh, in the scars on the body. The person is treated with some cruelty, like we can prove it. The physical cruelty, we can prove it. But for the mental cruelty, it is very difficult to prove. It has to be established by the circumstantial evidence and by producing the oral evidence. But the best witnesses to this cruelty is that husband or the wife. Husband or the wife. So here, in this case, the cruelty is not defined anywhere under any act. So it depends upon the person to person. It depends upon the case to case. So for example, if a person, if a person A is a wife, B is a husband. So A is a woman who has been brought up in a very high profile family, and she has lived her life in a very lavish manner. So she marries to a person who is a salaried, monthly salary guy. Meanwhile, while the marriage life is going on, there they have some disturbances between the there are some differences between disturbances because of the lifestyles. So for a person who has who has brought up in a high profile family, uh, the respondent is unable to provide that kind of status, that kind of family lifestyle to that woman. And apart from that, treating her with negligently or doing something else against her will give some kind of cruel to the person who has brought up in a high profile family, wherein because there will be no day for her to sleep with hunger, and this kind of things will be there. So depends upon case to case and facts to facts, the cruelty is defined. Even Supreme Court and different high courts of our different high courts of our India, nowhere it is discussed that, nowhere it is defined that this is the cruelty and this has to be followed. There is no measurement for cruelty. The cruelty is defined, and they has to be independent as to different each case. It is independent to the each case. So now we are going to the desertion. Desertion, that is class 1B. So here has deserted the petitioner for a continuous period of not less than 2 years immediately preceding the presentation of this petition. So here we can see, so where a person deserting the another petitioner. So if A is a husband and B is a wife, so if the wife deserts husband, leaving the conjugal life, leaving the matrimonial life without any plausible ground, that is reasonable ground, she left the husband and she lives separately for more than 2 years. For more than 2 years. So for more than 2 years, there is no cohabitation, there is no consummation of marriage, there is no intercourse between the two couples. So that will becomes a ground. Leaving a part for more than 2 years is a ground which can be bring into the uh, desertion. So to file a petition under this act, there shall be the mandate time period is 2 years shall be separation. That is a thing which we have to be noted. Keep in mind before making an application. Now coming to subclass 2, class 2. Who has converted into another religion? If a person who has converted into another religion, for example, A and B are Hindus by the time of marriage. B is the husband who converts into Christianity without intimation or without information to anybody else. Now he becomes a Christian. So now the marriage automatically, now this case, conversion into another religion becomes one of the best ground to get the divorce from the court. Get the divorce from the court. Next, coming to a person has incurably of unsound mind or has been suffering continuously or intermittently from mental disorder or of such kind, and to such an extent the petitioner cannot reasonably be expected to live with the petitioner. So here, if a person is suffering with incurable mental disorder or incurable unsoundness of mind, or incurable, that means which is unable to cure. So in these cases, it will definitely cause us hardship to another person. So considering this and taking this ground, this is the unsoundness of mind as a ground, we can file a petition for divorce. Now coming to person has been suffering from a virulent and incurable form of leprosy. So leprosy, which is incurable form, is also a ground for filing a divorce petition. Now, and another one is venereal diseases in a communicable form. Venereal diseases means the diseases which will spread when two persons came into a physical contact. So when these disease, when a person, either of the person is either of these spouses is suffering with the venerable diseases which is in a communicable form. That means spreading in a spreading form. So that contaminating and spreading form. So that is also a ground which is a incurable disease that has to be noted. So the disease shall be incurable disease, venereal disease in a communicable form is also a ground for seeking divorce. Has renounced the world by entering any religious order. So here, so సన్యాసం పుచ్చుకోవడం అంటారు. Renouncing the world means సన్యాసం పుచ్చుకోవడం. So ఒక వ్యక్తి either A or B, a wife or husband, renounces the world by accepting renouncing the world by accepting some of the religious orders. So if any of the person becomes sannyasi, so the other spouse, that becomes a ground for other spouse to file the divorce petition. Next one. If a person has not been heard for a period of 7 years or more by those persons who would naturally have heard of it had that party been alive. So here this is a provision which is related to Indian Evidence Act also, that is section 107, 108. So wherein it was, it was discussed that if a person is not heard for more than 7 years, it is a presumption under the law that it is presumed that the person is dead, presumed to be dead. So this has been taken and it has been incorporated here. If A and B, if B is a person who went for some traveling to the world trip like that, so he went there, he went like that, but he has not returned for more than 7 years, and he has his presence and his whereabouts were also not known to any of the persons. So in that case, that that also a ground for taking divorce from the court of law. Now there is an explanation that is mentioned in section 13. In this subsection, the expression desertion means the desertion of the petitioner by the other party to the marriage without reasonable cause and without the consent or against the wish of such party, and includes the willful neglect of the petitioner by the other party to the marriage, and its grammatical variations and cognate expression shall be construed accordingly. So the explanation they have mentioned what should be a desertion, what shall be a desertion, like that. So wherein, so without any reasonable cause and without the consent of the opposite party and against the wishes of the other partner of the marriage, some person willfully neglecting them and leaving separately from the one partner of the marriage, one spouse. So that has to be considered as a desertion. Now coming to subsection 1A, either party to the marriage, whether solemnized before or after the commencement of this act, may also present a petition for dissolution of the marriage by a decree of divorce on the ground that there has been no resumption of cohabitation as between the parties for the period of 1 year or upwards, whether the passing of decree for a judicial separation in the proceedings to which they were parties. So as we discussed in section 10, so judicial separation, if there is no cohabitation between the parties for 1 year or more, then it will becomes a ground for the judicial separation. I mean, it will becomes a ground for the divorce. Now coming to subsection 1A clause 2. So that there has been no restitution of conjugal rights as between the parties to the marriage for a period of 1 year or upwards after passing of the decree for restitution of conjugal rights in a proceeding to which they were parties. So as we discussed in section 9, so even after passing a decree of restitution of conjugal rights, if either of the party against whom the order is passed is fails to comply the order of the court to join the conjugal company of the another partner, definitely that amounts to a ground for the seeking the divorce to the party who has got the conjugal restitution of conjugal rights order. Now, this section 13 subsection 2 is specifically for a wife. These grounds are only for the wife who is intended to file the dissolution of marriage, that is divorce. So in the case of any marriage solemnized before the commencement of this act, that the husband had married again before such commencement, or that any other wife of the husband married before such commencement of act was alive at the time of solemnization of the act. So this specific clause is similar to the essential conditions of the marriage, section 5 subsection 1. So this section also says that if for example, as we discussed, prior to 1955 there is a polygamy, that is a male marrying 2 or 3 wives, more than one wife. So in that case, if a woman marries that person who is having a spouse after this enactment, she can seek for divorce. Prior to this amendment, since there is no provision for the woman to take divorce, so there were many women who was lived like that and spend their life. But the woman who wants to come out of the relationship, like who doesn't want to be a second wife, who doesn't want to be a third wife, she can file a petition under this section 13 subsection 2. So saying that he is already having a woman in his life and he married to me as a second wife, so I want to come out of the marriage. That is the ground for this. That will be the ground exclusively for the woman to come to file for the dissolution of the marriage. Now coming to the subsection 2 of subsection 2, class 2 of subsection section 2, that the husband has, since the solemnization of the marriage, has been guilty of rape, sodomy, and bestiality. So if the husband is guilty of offense under section 375, 376 of Indian Penal Code, and bestiality and sodomy, which are the unnatural sexual offenses. So if he is guilty of these kind of offenses, it becomes a ground for the wife to seek the divorce. Now coming to class 3 of subsection 2 of section 13, that in a suit under section 18 of Hindu Adoptions and Maintenance Act, or in a proceedings under section 125 of Code of Criminal Procedure, or in the proceedings in section 125 Code of Criminal Procedure, a decree or order, as the case may be, has been passed against the husband, awarding the maintenance to the wife, notwithstanding that she was living apart, and that since the passing of such a decree or order, cohabitation between the parties has not been taken place. So here, if an order is passed, that is section 18 deals with the maintenance of wife. Section 18 of Hindu Adoptions of Maintenance Act deals with the maintenance of the wife. If the wife gets an order under section 18 or section 125 of CRPC, 125 of CRPC, if the husband fails to comply the order and they live separately for more than 1 year, without compliance or without compliance of the order, they are living separately, then that also becomes a ground for the wife to file the divorce petition before the court of law. Next, that her marriage, whether consummated or not, was solemnized before she attained the age of 15 years, and she has repudiated the marriage after attaining the age, but before attaining the age of 18 years. So here, this specific provision is relating to section 6, with during the situations of the child marriages where it were happening. So in that period, if the bride is of 15 years or 15 less than 15 years of age, if she came to know that marriage is that the marriage was performed against her will and wishes, so during that time only she has reputed. That means she has not accepted the marriage, knowing that marriage was the child marriage, or that was against her wishes. Then she can file the petition under this act after attaining the majority. She has reputed the marriage after attaining that age, but before attaining the age of 18 years. So this, as per this section, she can file the petition before 18 years itself. So that is clear from the wordings. That means that her marriage, whether consummated or not, was solemnized before she attained the age of 15 years, and she has repudiated the marriage after attaining that age, but before attaining the age of 18 years. So before attaining the age of 18 years, she has to make an application before the court to uh, take the divorce from the court of law against the marriage. So that is section 13, the grounds of section 13. So there are common grounds for husband and wife, and there are certain specific grounds that are mentioned in subsection 2 of section 13. Section 13. Now coming to section 13, wait a minute.
సార్ అభిలాష్ గారు కంటిన్యూ చేస్తాం లేదా నెక్స్ట్ రేపు తీసుకుంటారా?
సార్ 15 వరకు చెప్తాను సార్, 15 తర్వాత చేద్దాం సార్.
సరే మళ్ళీ
Section
కంటిన్యూ
15
రేపు ఈవినింగ్ కావాలా?
సెక్షన్ 15 వరకు చెప్పేస్తాను. ఒక 1 minute వేరే కాల్ వచ్చింది వాళ్ళు, ఒక్క నిమిషం.
ఓకే ఓకే.
Now we will discuss about section 13A, alternative relief in divorce proceedings. Alternative relief in divorce proceedings is sumoto powers that is granted to the court, or you can make an application. Uh, you can make an application, or the court can grant sumoto orders under section 13A. That is alternative relief in divorce proceedings. In any proceedings under this act, on a petition for dissolution of marriage by a decree of divorce, except in so far as the petition is founded on the grounds mentioned in class 2. I mean subclass 2. That is that we can say that is a conversion into another religion, and class 6, that is renouncing the world, and class 7, that is not heard for 7 years. Of subsection 1 of section 13, the court may, if it considers it just so to do, having regard to the circumstances of this case, pass instead a decree for judicial separation. So if the court feels that the judicial separation will help the spouses, will help this marriage institution, and to continue further, the court can order the judicial separation, except in the cases where that is when the spouses have renounced the world, when either of the spouse has converted into another religion, and when this when either of the spouse is not heard for 7 years. So except in those cases, the court can order for judicial separation for 1 year summatively, or by an application by the parties. Now, coming to that is the alternate relief in divorce proceedings. So the court feels that there is a possibility of reunion or something else. So the spouses to the marriage, they can live together, and they can live. So then if the court feels fit, then it will order the alternate relief of judicial separation in the divorce proceedings. Now coming to this section 13B, which is a trending divorce in the current Indian society. That is